Good afternoon, class. Now we are going to start with the provisions of the new civil code on the law on obligation and contracts. Let me share with you my screen. Okay, chapter 1 and 2. Okay, class. We start with Article 1156 of the new civil code. Article 1156 provides for the definition of an obligation. Under Article 1156, I want you to memorize this definition, class. Article 1156. An obligation is a juridical necessity to give, to do, or not to do. No, I will repeat the definition under Article 1156. An obligation is a juridical necessity to give, to do, or not to do. Okay? Now, when you say obligation, that means that you are bound to render something to another. No? Okay, let us go with the definition first. When you say obligation, again, that means that you are bound. You are duty bound to render something to another. Now, when you say juridical necessity, that means that the obligation must be fulfilled or performed. Otherwise, there will be corresponding penalty for non-compliance. That juridical necessity means that if the obligation has not been performed or if the obligation was violated, then it gives the other party, no, or the aggrieved party a remedy to go to court and ask for a particular relief. That means that he can invoke the power of the court to order the other party to comply with the obligation. Now, you will see there different prestations: to give, to do, or not to do. Okay, to give, meaning to say the delivery of something, to do, the performance of an act, or not to do, the prohibition not to perform a certain act. So an obligation is a juridical necessity to give, to do, or not to do. Okay, class. This is the definition provided for under Article 1156. You will note, class, that the obligation not to give, was not included in the definition provided for by law. I will repeat, the obligation not to give. No? Mag-iisip kayo bakit kaya wala dito sa ibinigay ng batas. Okay? Now, class, the obligation not to give, class, is actually included in the obligation not to do. Okay? All right. Okay, so that is the statutory definition of an obligation. Let us proceed forward. Let us go to the requisites of obligation. Now, in every obligation, there is always the presence of a passive subject. Now, the passive subject is the party which is bound to perform the obligation. Now, when you say passive subject, this is the debtor in an obligation. The debtor or the passive subject is the person who is bound to perform the obligation. On the other hand, the active subject or the creditor in an obligation is the one who is interested in the performance of the obligation. No? If the passive subject is the one who is bound to perform the obligation, the active subject is the one interested in the performance of the obligation. Now, the third requisite of an obligation is the juridical tie. The juridical tie is what binds or connect the parties. This is the legal relationship between the parties. Now, what connect the parties together is what we call the juridical tie. Okay. Then the fourth requisite of an obligation is the object. The object is the subject matter in an obligation. Now, there are different kinds of obligation. Number one, real. Number two, personal. No? The real obligation consists of an obligation to give, while a personal obligation consists of an obligation to do or not to do. In other words, class, a real obligation involves delivery of something to another person, while a personal obligation involves rendering some service. Okay? Now, okay, under the Civil Code, no, there are several sources of obligation. No? What are the sources of an obligation? Now, obligation arises from law, acts or omissions punished by law, contracts, quasi-contracts or quasi-contracts, and quasi-delicts or quasi-delict. So let us take this topic one by one. Now, these are the sources of the obligation. The first source of an obligation is the law. No, we have defined the law as a rule of conduct, just and obligatory, no, promulgated by the competent authority for the good, for the observance of the common good. Now, that is the law, no, which is a source of an obligation. Now, if you have committed certain acts or you refuse to perform a certain act which is required to be done by the law, then you commit what? Criminal offenses. No, criminal offenses, which is also a source of an obligation. No, if you have committed a crime, for example, then you are what? Under obligation, or there is a juridical necessity to return the property. For example, no, if the crime of theft was committed, then it gives rise to an obligation to return the property subject of theft, which is why a criminal offense or an acts or omissions punished by law is also a source of obligation. Now, another source of an obligation are contracts. Contracts, class, are agreement. These are covenants entered into by private individuals. No, the private individuals, or it's a private agreement between two individuals, wherein two individuals bind themselves based on the terms and conditions of the agreement. Now, a quasi-contract is not a contract. No, a quasi-contract is not a contract, but there exists a juridical relation resulting from what I call as love, L-U-V. No? Lawful, unilateral, and voluntary act, class. Now, it is a juridical relation resulting from lawful, unilateral, and voluntary act. What do we mean by this quasi-contract? No, a quasi-contract, no, class, kaya yan tinawag na quasi-contract kasi para siyang contract pero walang kasunduan. Walang agreement, walang prior understanding. No, for example, there are two kinds of quasi-contracts, class. No, negotiorum hestio and solutio in debiti. No, negotiorum hestio and solutio in debiti. Solutio in debiti means payment by mistake. No? Nagbayad ka pero mali ang pinagbigyan mo ng bayad or sobra ang ibinayad mo. Now, in case of solutio in debiti, which is a quasi-contract class, if a person has paid by mistake, meaning he has paid not to the person to whom the payment is due, or if the payment is in excess of the amount which is due, then there creates an obligation on the part of the payee or the person receiving the payment to what? To return the excess or to return the payment made by mistake. This is what you mean by a quasi-contract. No, it proceeded from a lawful, unilateral, and voluntary act of one person giving rise to the juridical relation between the payor and the payee. Now, the other type of quasi-contract is what? Negotiorum hestio. Negotiorum hestio is a type of quasi-contract. Under this contract, now for example, your neighbor is on a vacation and all of a sudden, the community was inundated by flood. No, binaha. Now, class, in case that the community is inundated by flood and that your neighborhood exerted efforts and spent on resources to salvage your property and important belongings, no, there creates what? A quasi-contract. Wala kayong kasunduan, class, bago ka umalis at magbakasyon na that your neighbors are in charge of your property. There is no prior agreement. There is no prior contract. No, there is no agreement or covenant whatsoever. But because your neighbor has salvaged or saved your properties, then there creates an obligation on the part of the property owner to reimburse the neighbor of the expenses incurred in saving the properties of the owner. Now, in this case, the law will impose obligation on the owner of the property to reimburse his neighbor who has salvaged the property from being destroyed by flood. So this is what you mean by lawful, unilateral, and voluntary act. That lawful, unilateral, and voluntary act, class, pertains to the what? The act of the neighbor in saving the property from being destroyed by flood. Because of this lawful, unilateral, meaning to say it is upon the initiative of the neighbor to save the property, and voluntary, class. No? Voluntary act. Lawful, unilateral, and voluntary act that the law imposes an obligation on the part of the owner to reimburse that neighbor from the expenses that he or she has incurred in saving the property. So in a quasi-contract, class, there is no contract, strictly speaking, but because of the love, the LUV, lawful, unilateral, voluntary act, then there creates an obligation. Okay? Now, quasi-delicts. These are what? Damages arising from tort or civil act which is not amounting to a crime. Okay, these are, class, the 5 sources of an obligation. Okay, under Article 1157. Okay. So class, under 1158, no, only those obligations which are expressly provided by law are demandable. No? Which means to say, or which goes without saying, that if a particular act has not been ordered by law or has not been expressly provided by law, then such obligation is not presumed to exist. Kung wala sa batas, class, ibig sabihin, walang obligasyon. Okay? Contract, on the other hand, has the force of law as long as all the essential requisites of a contract are present. Now, we will discuss contracts in the finals, no? Because the subject obligations and contracts. In the prelims or preliminary exam, our coverage is from the nature and effects of obligation to different kinds of obligation. For the midterms, we will have extinguishment of obligation, and for the finals, we will discuss contracts. Okay? Now, as long as the contract has all the essential requisites for its validity, then it has the force and effect of a law. Okay? Now, in case a contract is violated or breached, then the aggrieved party can go to court and seek for redress of his grievances. Okay. Now, take note of the concept compliance in good faith. When you say compliance in good faith in relation to contracts, that means that you have to perform the obligation according to the terms, no, according to the terms and conditions of the contract. So you got there quasi-contract, lawful, unilateral, voluntary. And there are 2 kinds of quasi-contract which are flashed in your screen. You just go over them. Now we have discussed them earlier. Okay. Of course, class, crime, no, crime or delicts as a source of obligation is governed by criminal laws or penal laws. So under the Philippines, we have the revised penal code and other special penal laws. We will not discuss them because the subject will deal only with what? Civil obligations or the law on obligation and contracts, not criminal. Okay? Okay. But you will take note, class, that under Article 100 of the Revised Penal Code, every crime, no, all criminal violations has a corresponding civil liabilities. No, basta may krimen, meron niyang civil liabilities. Class, pag sinabing criminal liability, you are pertaining to imprisonment or yung pagkakakulong. When you say criminal liability, it may also pertain to the payment of fine. Pag sinabing fine, class, yung multa. No? These are criminal liabilities. When you say civil liabilities, no, it can be in the form of restitution, meaning to say you have to return the property stolen, or in case that the property is no longer available or the property is considered as lost, then you will just have to pay or to return for the value of the property. That is what you call as restitution. Another civil liability arising from crime is reparation. You have to pay damages for whatever inconvenience that the commission of the crime has caused against a party. Then indemnification or the payment of damages. These 2 concepts are similar. Okay. Now, quasidelics, no, this is what we have discussed earlier. No, these are damages to another person without a contract. Okay. What are the requisites of a quasidelic? There must be fault or negligence, no? Uh, and there is act or omission where there is no pre-existing contract, and then damage caused, okay, to another. Okay. Now, under Article 1162, no, there is a comparison between what? A crime and a quasidelic. No, a crime may involve malicious intention, while a quasidelic will not. It's the source of the criminal liability is negligence. Okay. Okay. Now, okay. 1163 class. No. It is an incidental duty to preserve a thing with ordinary care or the diligence of a good father of a family to ensure the delivery of an obligation and prevent negligence of the debtor. Furthermore, parties can stipulate another standard of care. So class, no? If the obligation consists of delivery of a specific thing, then the law imposes what? The diligence of a good father of a family. No? Class, magtataka kayo bakit good father of a family? Bakit hindi ginamit yung good mother of a family? Kasi class, yung good father of a family is borrowed from the Roman law concept. During that time, no, only in the Roman Empire, no, only men can enter into a contract, no, in the society, which is why the diligence required is diligence of a good father of a family and not a mother of a family class. No? Okay. Now, if the obligation consists of the giving of a specific property, then the law gives the what it is called as incidental duty. When you say incidental duty, that duty comes with it. For example, you are obliged to deliver, no, a specific thing. Then it comes with it, there is an incidental duty. Now, that obligation comes with it, the obligation to take care of what? That specific property. Okay? So that diligence of a good father of a family is the standard care or the ordinary care. Kasi class, if a person who is obliged to give something is not obliged to take care of that object or thing, then the obligation will be rendered nugatory. Ibig sabihin, class, parang baliwala yung obligation. Kasi wala kang obligasyon na pangalagaan yung property na yun. So, if you are obliged to deliver something, the law gives you an incidental duty, class. An incidental duty to take care of that object or property. No? Okay. Now, class, can the party stipulate for a higher standards of care? The answer is yes. For example, the parties want to ensure that the obligor will deliver his part of the obligation. Then the parties are free to do so. So the standard of care, the diligence of a good father of a family is the default care. Hindi pwedeng walang default care. Hindi pwedeng walang care because otherwise, it will render the obligation nugatory. It will not create a juridical necessity to deliver the object because the obligor is not obliged to take care of the property. No? Okay. That is what you mean by 1163. Okay? Now, while ordinary care is the standard care or the default care, extraordinary care is the highest standard of care observed by the common carriers and banks. Class, lahat ng obligation, no, ang standard care niyan is ordinary diligence. Now, there are certain what? There are certain contracts or obligations which does not involve or does not require ordinary care but the exercise of extraordinary care or the highest standard of diligence. No? What are examples of this? Common carriers class, yung mga public utility vehicles natin. Public utility jeeps, no, the buses, yan. These are common carriers. No, yan ang tawag sa batas as opposed to private carriers o mga private vehicles. Common carriers class, yung mga public utility vehicle natin, under the law, they are obliged to observe the extraordinary care or the highest standard because the law wants to protect the general riding public. Okay. The bank's class also, as a financial institution, is required by law to observe extraordinary care. Ibig sabihin yan, class, the banks are what? Expected or set to a higher standards than all of the businesses. No, because it involves integrity in the banking system or integrity in keeping of the deposits of the general public. Okay? Okay? Law imposed the standard of care, therefore parties cannot stipulate that there should be no standard of care because the obligation will become useless since there is no obligatory force. So class, the parties can only stipulate to a higher standard of care. Now, because the default care is what? The diligence of a good father of a family. Now, what the parties can agree on is a higher standard of care. No, not a lower standard of care. Because if the parties can be allowed or if the parties are allowed to stipulate for a lower standard of care, then it will render the obligation useless because the party can just ignore or neglect the care of a particular thing or object to be delivered. Okay? Okay. Class, take note that Article 1163 will apply only in case that the object to be delivered is a determinate or specific object. Kasi class, there are two kinds of object. It can be what? It can be specific determinate or it can be what? Generic or indeterminate. Now class, take note that Article 1163 will apply only if the object of the obligation is a specific obligation. Specific or generic obligation. Article 1163 will not apply in case the object is what? Generic or indeterminate. Ha? The generic or indeterminate. Hindi yung the generics pharmacy class. Iba yun. Okay. 1163 will apply only. In other words, class, the diligence of a good father of a family will apply only in case the object is determinate. But if the object is indeterminate or generic, then there is no obligation on the part of the obligor or the debtor or the passive subject to observe the diligence of a good father family in taking care of the property to be delivered or the obligation to be performed. Now, why class do we say that 1163 applies only if the property involved is what? Specific or determinate in nature? Kasi class, okay, no? When you say specific or determinate, it has sufficient particularity. Okay. Class kasi, kapag determinate or specific ang property, it cannot be substituted if it has been lost. Kapag generic yung property, it pertains to a class or genus, you do not need to exercise the diligence of a good father of a family because genus does not perish. No? No, it does not perish. Kahit mawala, for example, yung iPhone, no? To deliver the iPhone. Nawala yung iPhone. You can replace the iPhone with another unit of the same kind and quality. Kasi class, ang pinag-agrihan nyo lang is iPhone. Walang specific descriptions. No, walang serial number, for example. The serial number will convert the iPhone from being generic to a specific object. And if it is a specific object, then under 1163, the obligor has to observe the diligence of a good father of a family. Genus never perishes. That is the principle involved. Okay. The debtor is not liable if failure to preserve the thing is due to a fortuitous event. Okay, class. No, a fortuitous event, ano bang ibig sabihin niyan? A fortuitous event is an event which is not foreseeable or if foreseeable is inevitable. Ibig sabihin, hindi mo pwedeng ma-foresee or ma-predict, or if it is predictable or foreseeable, you cannot prevent it. Okay? Now, if the object of the obligation is lost due to a fortuitous event, without the fault on the part of the debtor, then he is not liable. Okay? And again, exception to the general rule is when the obligation pertains to a generic thing, in which case, even if the object is lost, then the obligor is still required to deliver the thing because it is a generic thing. What has been lost is a generic thing according to the Latin principle genus non quam perit, genus never perishes. Okay? Real right is what acquired upon delivery, while ownership is transferred from the perfection of the contract. Civil law principle, accessory follows the principal. Okay. Now, when does the obligation to deliver the fruits arises? Now, this is the Article 1164. Kailan, no, when does the obligation to deliver the fruits arises? When, no, at the time that the contract is perfected, no, you are obliged to deliver the fruits. Kasi class, may mga different kinds of fruits: natural, industrial, civil fruits. No, civil fruits. Now, at the time that the perfection of the contract, you have to deliver the fruits. Obligation is subject to suspensive condition, contract of sale, etc., etc. Okay? So you have natural fruits, industrial fruits, and civil fruits. Natural fruit is spontaneous product of the soil and young of the animals. Now, without the intervention of human labor. Memorize, class, the definition of fruits. Natural fruits is the spontaneous product of the soil and young of the animals. Now, without intervention of human labor. While industrial fruits class pertains to what? The products produced by land through human cultivation or labor. Civil fruits pertains to that derived by virtue of juridical relation, just like payment of rent. Okay. Industrial fruit is that produced by land through human cultivation or labor. For example, if you have established a farm, no? If you have created a farm, and then you have, for example, planted some dragon fruits by cultivation or human labor, no? Pag namunga yan, ang tawag dyan, class, industrial fruits. Okay, personal right versus real rights. A personal right is a right or power of the creditor which is enforceable against a particular person or passive subject. A real right, on the other hand, is when the right or interest of the creditor over a specific thing is without a definite passive subject. It is enforceable against the whole world. A personal right, class, is enforceable against a particular person or passive subject. On the other hand, class, a real right is enforceable against the whole world. Pag real right, class, it binds the property regardless of the person against whom it can be invoked or it can be enforced against. No, kasi pag real right, it binds the property. It binds the whole world. No, kahit sino pwedeng bound by the performance of the obligation pursuant to the real right, no? Okay. Okay. This is the principle, class, I want you to remember. Accessory follows the principal. Anong ibig sabihin niyan, class? Accessory follows the principal. No? When the obligation has been perfected, the ownership was transferred from the seller to the buyer. Once the contract has been perfected, no, then the obligor is now bound to deliver the fruits of the principal. Kasi, class, accessory follows the principal. Kung ano yung principal na isang object, no, lahat ng accessories doon kasama. No, accessory follows the principal. For example, on September 1, 2020, A and B entered into a contract for the sale of a female dog, no, on October 1. Okay. So, i-deliver daw ni A kay B yung dog on October 1. But, okay, on October 1, nanganak yung aso that is supposed to be delivered by A. Now, question, who owns the puppies, A or B? Answer B. Kasi, class, at the time of October 1, meron ng obligation to deliver si A. Which is why, if you have the obligation to deliver the thing, then you are now liable to deliver the fruits as well. Because accessory follows the principal. Okay? Yun ang ibig sabihin nun. Okay. Now, there are three essential requisites on the perfection of a contract: consent, object, payment, or consideration. We will discuss this one as when we reach the law on contracts. Okay? Okay. Okay. In case two contract of sale was executed, okay, the remedy is the recovery of ownership because of the acquisition of ownership from the time the contract has been perfected. Okay, class. Pag nag-enter ka into a contract at hindi pinreform yung contract, na meron ka palang personal right. A personal right to what? Against the creditor. No? But if the property has already been delivered to you, meron ka ng real right. No? The remedy now that you have is no longer specific performance to deliver the property kasi it has been delivered to you. Your remedy now is what? Recovery of ownership or ano? Or specific performance. Your remedy now is what? Recovery of ownership because of the acquisition of ownership from the time that the contract has been perfected. Okay? So the remedy of creditor in case of real obligation is to recover ownership or recover possession of the property. Okay? Specific real obligation can demand specific performance of obligation plus indemnity, rescission plus recovery of damage, and then payment of damage. Okay. Generic real obligation can be performed by third person. The creditor cannot force the debtor to make the delivery but can ask for performance of obligation, can cover damage in case of breach. Okay. As a general rule, class, if the thing is lost or destroyed due to a fortuitous event, then the obligation is extinguished. There are exceptions to this general rule. Number one is if the debtor has incurred delay. Number two, if the debtor has promised to deliver the same thing to two or more persons with different interests, or if the object is a generic thing. Okay, remember this rule and the exceptions. Meaning to say, under the exceptions, even if the thing is lost due to a fortuitous event, then the obligation is not extinguished. No, if the debtor has incurred delay or has promised to deliver the same thing to two or more persons with different interests, or if the object to be delivered is a generic thing because genus never perishes. Now, take note of the distinctions between accessions and accessories, class. When you say accessions, these pertain to fruits or additions or improvements. On the other hand, when you say accessories, these are things included or attached to the principal for better use or completion. Okay? Okay. So Article 1167. This article is about the breach of personal obligation. So when a personal obligation is breached, now what are the remedies? Specific performance is not applicable since this will be violative of the debtor's constitutional right against involuntary servitude. No obligations not to do, the obligor does it, the creditor may have it undone at the expense of the debtor. When the obligation consists in not doing, the obligor does what has been forbidden him, it shall also be undone at his expense. Okay? In reciprocal obligations, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the parties fulfills his obligation, delay by the other parties begins. Or the other begins. Okay? So class, in a reciprocal obligation, hindi ka magiging delay kung yung isang party is not ready to comply with his part of the contract. No? And then under 1169 class, there is the principle of no demand, no delay. No? Kahit na meron kayong agreement to perform the contract on June 1, 2020, at hindi mo yun na-perform, as long as wala pang delay, wala pang demand, hindi ka pa in delay. Okay. There are exceptions. Memorize the exceptions. Now, the general rule is no demand, no delay, except when the obligation or law so provides. Example, class payment of taxes. Pag hindi mo nabayaran ang tax mo on time, the government need not to send you demand to pay in order to put you in delay. Pag na-delay ka sa payment ng taxes, automatically, you will incur penalties and surcharges. Okay? Or when the time is a controlling motive or time is of the essence, class. Kahit walang delay, kahit walang demand, meron ng delay. For example, you are contracted to create or to make what? A wedding dress, a Americana, or a wedding dress, because the parties will contract marriage on October 1, 2020. And then class, come October 1, wala pa yung damit nila. So hindi kailangan magbigay ng demand letter, yung parties para maging in delay ka. Automatically in delay ka na. Because time is the controlling motive in the establishment of the corporation. Time is the essence. Kaya siya pinagawa sa'yo because of the occasion. So if you don't perform the obligation, you are already or automatically in delay. Or when demand would be useless as when the object of the obligation is lost or destroyed through the fault of the debtor. Okay? Delay or mora is the failure to discharge duty on date and time. we have two distinctions: ordinary delay and legal delay. Ordinary delay is when the party failed to perform an obligation on time. There is no punishment for this. While legal delay is the delay that results in breach of contract. Okay? Kinds of delay or default: mora solvendi, mora accipiendi, compensatio morei. No? In mora solvendi, the fault or delay is in the debtor. No, mora accipiendi, the delay in the accepting of the obligation, which is the fault of the creditor. And compensatio morei, where both parties have incurred delay. There is no delay in negative personal obligations. What do you mean by that? Ano ba yung negative personal obligation? The obligation not to do. Walang delay dyan because bawal mo nga gawin. From the moment that the parties enter into a negative personal obligation, immediately due and demandable na yan. Kung hindi niya na ginagawa, walang delay dyan. Okay? Pag ginawa niya, it will violate the contract. Okay? So, but hindi delay. Okay? When both parties are already in delay, there could be no delay. This is a rule of equity. For example, pareho kayo in delay, then the law will treat that there is no delay as between the parties. Parang negative, negative equals positive. The same equation. Requisites of delay by the debtor. There's failure to perform on the date agreed upon, demand made either judicially or extrajudicially, and the failure to comply with such demand. Okay. Grounds for liability. Take note, class. No, this is a very important concept. Fraud, deceit, or dolo. Deliberate or intentional evasion of the normal fulfillment of an obligation. It can be dolo causante or causal fraud, and dolo incidente or incidental fraud. Now, if the fraud is committed or existing upon perfection or commencement of the contract, then it is dolo causante. But if it's dolo incidente, fraud in the performance of the obligation, it has a different treatment in the law. Negligence or, okay, class. Going back, pag causal fraud or fraud in the perfection of the contract, no, you are liable to pay damages. Pero pag fraud in the, fraud upon perfection or commencement of the contract, it is a ground to annul the obligation para maging voidable ang obligation, no? On the other hand, if it's fraud in the performance of the obligation, it is not a ground to annul the obligation but to pay damages, no? You are liable to pay damages. And you have negligence, voluntary act or omission, there being no bad faith or malice, and prevents the normal fulfillment of the obligation. Delay, and if the performance is in contravention of the terms of the obligation. It covers all form of violation. Okay. Now, responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. So waiver for future fraud is void, while waiver for past fraud is valid because it serves as an act of generosity and magnanimity from the part of the creditor. So waiver arising from negligence is valid when the standard of care is the ordinary care or the proper diligence of a good father of a family, except if the stipulation requires another standard of care or ordinary care, just like a common carrier. There are kinds of negligence according to obligation: contractual negligence, culpa contractual, no, negligence in contracts resulting in their breach. The remedy of the creditor is to seek for the payment of damages. Civil negligence, culpa aquiliana, negligence which by itself is the source of an obligation between the parties, there being no existing contract between them. So examples: Quasidelic, the penalties, payment for damages. Criminal negligence or culpa criminal is when a crime is committed, no? So the penalty is imprisonment and payment of damages. Okay. Okay, these are self-explanatory. I leave them to you. Requisites of a fortuitous event, no? Independent of a human will or at least debtor's will, the event could not have been seen, or if foreseen is inevitable, impossible for the debtor to comply with this obligation in a normal manner. There is no concurrent negligence on the part of the debtor. No, those are the requisites of a fortuitous event. Please memorize. Memorize. Okay. So this is a repetition of the earlier slide. Okay. So take note, class, of the requisites for the recovery of interest, no, under 1175. So interest is due only, the payment of interest becomes due only if the parties have expressly stipulated for the payment of interest. There must be a written agreement. No, the agreement to pay interest must be in writing and the interest must be lawful. Now, under Central Bank Circular 799, when there is no stipulated interest, the legal interest shall be 6%. No? Okay. Okay, exactment of so just read them. No? They are self-explanatory. I leave them to you. So as a general rule, all rights may be transferred or transmitted, no, except when it is prohibited by law or it is prohibited by the stipulation of the parties. Okay, class, this ends, no, our presentation for tonight. No, thank you for listening and see you in the next episode. Bye-bye.